Steve. I'm Steve Skirka, your host this evening. It's going to be a very different program tonight because until the last quarter of the program, essentially I'm it. I'm going to be your host, moderator, speaker, guest, all of the above. It's my dance floor tonight, and I'm looking forward to it. So first of all, that was Boys to Men you listened to. We have a nice collection of songs at the end of the program for about 15 minutes, Coldplay songs if you'd like to stay. And I'll also give you a preview that the next program, we're going to have Norah Jones, who's coming out with a new record this month, both at the beginning and at the end of the program. And I just want to mention the next program. It's the Oscar Peterson film, Black and White. We're having Barry Averich, who is now an award-winning Canadian documentary filmmaker as of last night. Barry's film won 3 awards at the Canadian Screen Awards. We had a poster of it in the waiting room, the green room, and it's a brilliant film. And I just encourage you to tune into that program. It's going to be engaging and interesting. We're going to follow the greatest jazz pianist in history who happens to come from Montreal, Quebec. So we can all be very proud of that. All right, so let me tell you about tonight's program. We're marking the 15th anniversary of the Conrad Black trial. And I'll just tell you my involvement. Of course, I'm going to deal with this much more elaborately during the program, but I was the CTV legal analyst. I attended the trial in Chicago, many flights back and forth over the course of months. I remember one day at the beginning of the trial, I did 15 interviews, 15, starting at 5 a.m. because of the time difference, and then went into court and covered the case in court and did also programs and interviews in the evening. I don't know that I've ever worked as hard in my life as I did during this trial. And it truly is the Windy City because many of those interviews were outside, and I remember freezing as I did the interviews. So I covered the trial for CTV, and then I attended the appeals, and there were 2 appeals in the Court of Appeals in Chicago, and then one in the U.S. Supreme Court, which I'm going to talk about during the course of the program. And then Dundurn Press, a very established publisher in Toronto, brought me in to write a book. And I wrote a book, Tilted: The Trials of Conrad Black, in a first edition, then in an updated second edition. So I have an encyclopedic knowledge of this case, every aspect of it. And of course, I look at it through the lens of not just someone who covered it as a journalist, but I'm a lawyer and understood much of the trial through the lens of being a trained criminal defense lawyer, albeit the differences between the Canadian and American justice system. So with that background, I just wanted to tell you that in the last quarter of this program, we're going to hear from one of the jurors at the trial, James Kirby. And I'm going to be able to interview him. What's really interesting is that I can't do that with a Canadian juror. It's actually against the law. If a Canadian juror was to come on this program, he or she was to speak about their deliberations, they would be charged criminally. And I would be disciplined. I could be suspended or even worse for doing it. That's how egregious the conduct would be. Yet when I'm dealing with an American juror in an American trial, I get a free pass. So it's almost this delicacy that I'm never allowed to taste except once. And that's this evening. And I get to ask this juror questions that I could never ask anyone else. And it's interesting when we're talking about this juror, because I remember that there was a real concern expressed, particularly by the local press, that this was a Midwestern jury, blue collar, and they wouldn't understand the sophisticated nuances of the fraud that the prosecution was alleging in this case. And I just want you to remember that when you listen to James Kirby and you see what an intelligent, articulate man he is. And I just want to share a story with you about one of the jurors. And I've never told this story before. As I thought about it, preparing for this program, I realized that. And there was one juror, a young woman, who instead of taking notes would often doodle in her notebook. And she was quite prolific with her doodles. And we were very close to the jury box. It was a very small courtroom. Judge Amy St. Eve courtroom. And so we could see pretty well everything. And we sat on the side of the jury. And she would also curl her hair often. And unlike many of the other jurors who were taking notes, she rarely did. And during the course of the trial, some of the journalists mocked her for this, made fun of her. And I remember that I thought it was cruel. And I just resisted doing that during the trial, and I resisted doing it in my book. And I also thought it was wrong, beyond being cruel, because in Canada, for example, jurors don't take notes during criminal trials, and that may change eventually. They retain the knowledge, and they can ask questions during deliberations if they need their memory tweaked. But so that's the culture I come from. And so I just didn't accept that she wasn't paying attention beyond just the cruelty, and it really was quite cruel. So I wrote about the jury as being hardworking and conscientious in my book, and praised the jury and spent some time going through the reasons I believe that. And then I wrote the book and thought nothing of it. And 2 months after the book came out, I got a letter in the mail, and it was postmarked from Chicago. And I didn't recognize the person's name. It was a woman's name. And I thought, I wonder, what's this? And I opened it up, and the letter said, "Dear Mr. Skirka, I'm the juror who doodled." And she went on to say that she had spent some time after the trial reviewing all of the things that had been written about the trial and written about her, and how deeply hurt she was to read about, the derisive and insulting comments about her. And she said that I was the only one who had captured her fairly and respectfully. And she told me how much that meant to her and comforted her. And I felt, very good about that. So that's my unique story, never told before. So let's talk now about Conrad Black. So I remember the trial started on a Monday, almost exactly 15 years ago. And so I was invited as the CTV legal analyst, the legal analyst for the largest national television network in the country, to come into Fox News Sunday, Chicago Fox News. And they invited me in. They had a talk show and guests, and I was the lead item. And I'll never forget the first question that I was asked. Never. And the host looked at me after introducing me and thanking me for it. I said, "Who is this guy?" And that's the way Conrad Black was dealt with at the beginning of this trial. Who is this guy? Why is there so much attention paid to it? All the media trucks were lined up outside the courthouse. And so they had to pay attention, but they had no idea who he was and no idea why anyone cared about this case. Let me take it one step further. All of the prospective jurors in this case were given a 45-page questionnaire, probing many of their attitudes, their knowledge. By the way, completely foreign to the Canadian jury experience. We have no questionnaires. We know virtually nothing about our jurors when they sit in the jury box, other than their background, their occupation, what area they come from. North York, farmer, and that's about it. And our jury system functions very well with that. Virtually no one on the questionnaire, no one knew who Conrad Black was. They knew who Donald Trump was, because we're going to come to that. He was a witness in the case, but they had no idea who Conrad Black was. So he was essentially a zero in this case. And let's fast forward now to after the trial. Well, Conrad Black is responsible for striking one of the most important fraud statutes in American history, the Honest Services Fraud statute that was used in cases all across the United States every day, every year. And it was basically used to prosecute people who hadn't acted honestly. And because it was so broad and general, unanimous court struck it down, and there were a couple of companion cases, including the Enron case of Jeffrey Skilling. But it was Conrad Black whose case was heard first by the U.S. Supreme Court. And he's responsible for striking down the statute. I remember being at the hearing in Washington, and Justice Stephen Breyer, who's just retired and is being replaced, asked the prosecutor, wouldn't the statute capture an employee who takes home his or her laptop, the company laptop, and uses it personally at their home in the evening? And the answer was yes. They were in violation of this broad honest services fraud statute. So that's the first thing. And then from being a no one who knew I knew, on the last day of Conrad Black's hearing in the Court of Appeals, there was a ceremonial courtroom at the courthouse, the Dirksen courthouse. And outside the courthouse, I found a board where they had summaries of some of the most famous people who were prosecuted in the courthouse. And one of them was for Conrad Black. And I'll just read to you the inscription on the board that is permanently there in the Dirksen courthouse. The world's media came to Dearborn Street in 2005 when U.S. Attorney Patrick Fitzgerald brought 8 criminal charges against international newspaper mogul Conrad Black, Baron Black of Cross Harbor. 4 new charges were added later that year, alleging racketeering, obstruction of justice, money laundering, and wire fraud. Under the racketeering count, the government sought forfeiture of more than $92 million. A media circus erupted on the streets surrounding the Dirksen building, with photographers jostling one another for shots and staking out all 4 corners of the city block. After 12 days of deliberation, the jury found Black guilty of 3 counts of mail wire fraud and racketeering. On December 10, 2007, Black was sentenced to 78 months in jail. A subsequent appeal to the 7th Circuit was denied. Lord Black has appealed to the U.S. Supreme Court. Now, there are aspects of that that actually are inaccurate. But let me just tell you some of the other people who made the board in addition to Conrad Black. Thomas Edison, Charlie Chaplin, Marcus Garvey, John Rockefeller, and Alexander Graham Bell. That's the company that Conrad Black keeps on the courthouse. And we had a program on Conrad Black at the synagogue last January, about 14 months ago. And we had hundreds of viewers, and then we put it on YouTube. And there are 800 views of that on YouTube. And then if you look at the past Sunday, just 2 days ago, you ask what was the #1 story in Canada on Twitter that was being tweeted on Twitter? They call it trending on Twitter. Was it President Zelensky of Ukraine? Was it the Russian-Ukraine war? Was it the Grammy Awards that were being held that night? No, it was Conrad Black. It was Conrad Black who was trending first because he had written this column in the National Post deriding the alliance between the Liberals and the NDP, and as he described, the socialist piety of dental care and pharmacare. So he's someone who still commands a great deal of attention, both in Canada and in the United States. And of course, he's someone who was pardoned by Donald Trump. So he wins in the U.S. Supreme Court. We're going to talk about the case itself soon. And then Donald Trump pardons him. And so I want to deal with it in a bit reverse and talk about the pardon first, because I think it's important to understand the reason for the pardon. There are suggestions that Donald Trump's pardoned Conrad Black as a payback for some of the articles, the book that Black had written about Trump and had really been obsequious in his description. I mean, he even did it on the program that we had at the synagogue, standing up for Donald Trump as a superb American president. I think it's a dwindling number of people who hold that view, but Black still sticks to it. And I'm going to maintain that really the main fault, if you want to fault anyone for Donald Trump pardoning Conrad Black, lies with the prosecutors in his case. And why do I say that? Well, one of the counts, and by the way, I want to encourage you to ask questions. I know that I'm talking, but I will see the questions and I'm very pleased to answer them. So one of the counts that Conrad Black was charged with was fraud related to a birthday party for Barbara Miel at this French restaurant in New York City called La Grenouille. And it was described as one of the perk counts. There were 3 perks counts: a trip to Bora Bora, an apartment on Park Avenue that Conrad Black had used in part some of the Hollinger International, the company funds, to fund. And for this particular birthday party that the prosecutors chose to prosecute Black for, it cost $52,000, staggering amount of money for a birthday party. There was lobster, caviar, it was a feast. And some of the people who attended were the celebrities of the day: Barbara Walters, Peter Jennings, Henry Kissinger, Charlie Rose, on and on. But in addition to that, there were 14 directors for Hollinger International. 11 of them were at this birthday party. And Black had paid $20,000 out of his own pocket for the birthday party. Now, the interesting thing about this was that Donald Trump attended the birthday party and sat beside Barbara Miel. And it was after this birthday party that Black sold the headquarters of Hollinger International, which was on the Chicago River on a property, to Donald Trump, to the benefit of the shareholders of Hollinger International. And on that property now stands the Trump Tower, one of the largest buildings in the United States. So the notion that this was plundering the company was absurd. It was an absurd count. There was no way, in my view, the jury could ever find Black guilty of it, particularly because he put $20,000 of his own money. Because Trump used this to enhance the relationship with Black, which led to the sale of the property for Trump Tower. And so why did the prosecutors add this count? They added this count, in my view, simply because it showed an ostentatious man who would earn the wrath of the jury. It was to get the jury angry. I mean, how many of them made $52,000 a year? And here was $52,000 being expended in one night for this lavish birthday party. And so when Donald Trump becomes president, and this case comes to him, he's not just looking at this through some legal advisor's file. He was a witness. And we're going to talk about what happened to him, but he was a potential witness at this case. He knew the case was ridiculous because he was aware that Black was charged with this count. So he didn't need to be educated about it. It was the prosecutors that educated him by charging Black with this outrageous count. Trump knew Black because they were neighbors in Palm Beach. Trump had spoken at a shareholders meeting, contentious shareholder meeting in 2003. And so Trump had an understanding and feeling of the frailties of this case. And so when Conrad Black gets the part, he doesn't just get called by some bureaucrat, some government official. He's sitting at his home in Toronto late one night. The phone rings. And the person in the line says, "This is the White House. Could you stay on hold?" And Donald Trump gets on the phone. And I know this because I've interviewed Conrad Black about it. And Trump gets on the phone and says, "I know this case is ridiculous and I'm pardoning you and I want to end this misery." And I'm paraphrasing. And so you'd say, well, still, Steve, that doesn't prove, this wasn't payback. And I'll tell you what does. Because Black gets a subsequent call from the president. The president calls Black about this. And there were 2 co-defendants, Jack Boltby and Peter Atkinson, who still had convictions, served their sentences. And Trump phones Conrad Black and says, "What about Atkinson and Boltby? Were their cases just as outrageous as yours?" And he's absolutely. He says, "Well, I'm going to pardon them too." And he's pardoned them. He pardons Boltby and Atkinson. Now, if Trump was only paying back Black for what he had done for him, why would he pardon the other 2 men? So it's quite clear, in my view, that if there's blame to be shared, the large part of the blame for Black's pardon, if you're critical of it, lies with the prosecutors in the case. So let me tell you a bit more about Trump's testimony. So I've told you that Donald Trump had this relevant evidence to give on the perk charge, but he never testified. And he was being brought to court. At this time, The Apprentice was on television. It was a big hit. So he was a celebrity. And Amy St. Eve, the judge in the case, took special precautions to allow him to come. And just the night before he's set to testify, he's canceled. Eddie Greenspan calls him off. And the question is, what happened? And the reason is that Eddie Greenspan finds out that Conrad Black had sent Trump, a 2-paragraph letter deriding the government's case. And Eddie thought that would just be too much for the jury to, the government would just eviscerate him on cross-examination, and it would be bad for Conrad Black that he had sent this. So that's the reason. So Black essentially is the reason for the fact that Donald Trump never does testify, but he was prepared to. So let me now tell you what the case was about. Was divided really into 3 components. One was the perks, which I've already reviewed. The second was the videotape of moving in the boxes. And the third the large body of the indictment related to non-competition agreements. And Conrad Black and David Radler, who was the critical witness against Black, had built up the 3rd largest media empire in the world, Hollinger International. They owned newspapers such as Jerusalem Post, the Daily Telegraph in England, the Chicago Sun-Times, the National Post, and they had built up this huge empire. And in addition to that, they had a series of American newspapers in small towns, even some cities throughout the United States, community newspapers that they had collected. And David Radler's role, he was in charge of those American newspapers, which is very important to understand. Anyways, Black and Radler realize the internet is coming. They feel that it will damage the newspaper industry, and they decide to sell much of what the empire is. And what they do during the course of the sale is they build in non-competition agreements, which is a routine part of selling a newspaper. What is a non-competition agreement? The purchaser of a newspaper doesn't want to be concerned that once they buy the newspaper, the seller is going to go into competition with them and will set up a competing newspaper in the same city or town. So as part of the contractual agreement, they require the seller to sign this non-competition agreement, agreeing not to go into competition. And there's value to that. And the purchaser pays for that. And in the case of Can West, the National Post sale, Izzy Asper, who purchased the National Post, paid a non-competition agreement of over $20 million to Conrad Black. And interestingly, the fraud alleged against Black and his senior executives originally was $84 million. It changed, it was reduced to $60 million when the US government realized they couldn't sustain the charge. Because Izzy Asper would come to court and say, no, I didn't want Black to be my competition. I wanted to pay that money. It was worth it to me to pay $24 million to not have Conrad Black in competition. So the government was forced to remove that and reduce it to $60 million. So here's where the problem came. The problem came, Radler secured the non-competition agreements for all of the American newspapers. And that's where the $60 million that was collected in non-competition agreements came from. Now, Conrad Black relied on Radler, but in addition to that, Mark Kipnis, who was the lawyer for Hollinger International, sent the non-competition agreements and the payments that were being given for them to an audit committee, an international audit committee, that included a former governor of the state of Illinois, Jim Thompson, who was also a U.S. prosecutor, a former nuclear arms negotiator, Richard Burt, and an internationally renowned economist, Jose Marie Kravis, the wife of Henry Kravis. And as I wrote in my book, this wasn't my cousin Vinny. And they all approved these non-competition agreements. So in addition to Black being able to rely on Radler securing these non-competition agreements genuinely, which I say was, again, routinely part of a newspaper sale, he also had the audit committee signing off and approving. In addition to that, you had a law firm, Torrey's, and an international accounting firm, KPMG, that were aware and knowledgeable about aspects of these non-competition payments. So what happened is that when the case came to trial, all of a sudden the audit committee took the position, well, they may have signed off, but they really weren't aware of the content. And but as I say, these were not people who were, just came to this casually. And in addition, the government made a deal with David Radler. And in order to secure his testimony, Radler came to court and testified that he had a series of discussions with Conrad Black, and it was Conrad Black who initiated the non-competition agreements for these American newspapers. There wasn't a single document, there wasn't a single email, there wasn't a single telephone record that supported Radler's position. And so, again, putting aside the videotape and the boxes for a moment, my view was that this was an extremely weak case. Looking at it through the lens of, as a criminal lawyer, you had Radler unsupported by any evidence. He was in charge of the American newspapers. He was in charge of securing these non-competition agreements. And more importantly, it had been signed off and approved by this audit committee and included in public filings that the government was made aware of. So I thought that it was an extremely weak case on the fraud related counts. In the end of the day, just to fast forward so you know where Black is now, there was one particular transaction, the Forum-Paxton transaction, which was the smallest of all of the non-competition agreements. Conrad Black benefited, made $285,000. In a $60 million fraud, he made $285,000 on this transaction. But Mark Kipnis, the lawyer for Hollinger International, never got the approval of the audit committee for this particular transaction. And that is the only count, Forum-Paxton, that remains against Conrad Black. The one where Kipnis neglected to get the approval of the International Audit Committee, this audit committee. Of course, how would Black know that the audit committee had not signed out? How would he know that Radler hadn't seen this? I mean, that's another issue. Miguel Estrada, who defended Black in the U.S. Supreme Court, called the fact that this can't remain against Black a travesty, and I think there's some merit to that. My view is that really, at the end of the day, U.S. Supreme Court should have just wiped the slate clean on these fraud counts. And again, you're welcome to question me. You're welcome to ask, to challenge me. That's fine. But at least I want you to have some understanding of how this came about. Now, let's talk about David Radler for a moment, because it's very important to understand his testimony. Radler was in the same position as Conrad Black. They were in equivalent positions in terms of their management, ownership, seniority, and Hollinger International. Eric Sussman, the lead prosecutor in this case, told me that they knew they couldn't prosecute Black unless they had Radler's cooperation. There was no way, and again, just the way I've laid it out for you, it's clear, without Radler saying that he had the discussions with Black where Black initiated the suggestion of these non-competition agreements, there was no case. Now, Black and Radler were looking at decades of prison if they were convicted of these charges. Decades. Eddie Greenspan said to me that his client would die in jail. He suggested that his client was looking at 40 years. I heard other estimates of 25 years, but there's no question that these two men were looking at decades in prison. And you should know that in America, unlike Canada, you serve 85% of a sentence. So if you get a 10-year sentence, you serve 8.5 years, 20-year sentence, 17 years. So the prosecutors go to Radler, who's Canadian, from Vancouver, through his lawyers, and they make a deal with him. And the deal is that he'll get 29 months that the judge will sign off on. 29 months instead of 20, 30, 40 years in prison. 29 months, but it gets sweeter than that, because they'll agree that they won't oppose him being transferred to a Canadian prison where he'll be eligible for parole and likely get out in 6 months on parole. So Radler makes this deal to testify against Black for essentially 6 months in a Canadian prison, instead of decades of his life dying in prison. And all he has to do is deliver the goods against Conrad Black. Now, I want to highlight a difference between the Canadian criminal justice system and the American, because it's so critical to understand. When Paul Bernardo was prosecuted, Carla Homolka, as we all know, testified against Bernardo, and there was this incredible deal that came under scrutiny and led to a public inquiry being called. But she testified against Bernardo. When she testified against Bernardo, she had been sentenced. So when John Rosen, Bernardo's lawyer, stood up to cross-examine her, he could cross-examine her on the deal she made, on the sentence she received. And the jury was aware of it and could take that into account in determining its verdict. In America, what they do, they don't do that. They hold off the imposition of the sentence on the cooperator until he or she testifies, and the prosecutor, the government, can assess whether or not they've come through for them. And then at the end of the day, based on that determination, if they've lived up to their plea agreement, then they can get the sweet sentence. And if they don't live up to that plea agreement, all bets are off. Now, what does that encourage? What that encourages is perjury. What it encourages someone kowtowing to the prosecutor. Who's going to go against the prosecutor? Does truth matter, or does saving decades of your life matter? That's the dilemma that Radler had. And indeed, after Black is sentenced by Judge Amy St. Eve, she brings Radler into the courtroom and he gets his 29 months. As it turns out, he doesn't get out in 6 months. There's a lot of controversy. He serves about 1 year in prison rather than the 6 months. But he believed he was going to get out in 6 months. And so you have this incredible system that's so unjust, that really promotes injustice. Because all Radler had to do was sing the tune. Remember, I told you there wasn't a single document that backed him up. He just had to say, look, Black initiated the non-competition payments on these American newspapers. It was Black, not me. Even though I was in charge of the division, even though it was my domain, no, it was Conrad. And so that's what the jury heard. And the jury didn't have the ability, as a jury would in Canada, to assess the credibility of Radler based on the sentence he received, because Radler hadn't been sentenced yet. So it's so important that you understand. And people can take issue with Radler, but look at the choice that Radler had. And just consider, let's personalize it. Imagine if you had a friend or neighbor or relative. And this is the situation, the dilemma they were confronted with. Innocent of the charge. Plead guilty, you'll get 6 months. Risk a trial, even though you're innocent. Risk a trial, and you potentially go away to decades in a U.S. prison. And you can see how even innocent people get trapped and plead guilty in a system like that. It's not an easy thing to do, as Mark Kipnis did in this case, who was completely innocent and ultimately found innocent. This kind, decent man whose life was destroyed by this prosecution. I got to know him very well during the trial. Lovely family. And he took that risk. He went to trial and ultimately won. But what did he win at the end of the day? All right, so I can see that I have no questions, and we're getting closer to the time that our juror is going to come in. So I just want to see if I can cover a couple more things. Let's talk about Eddie Greenspan for a moment. Eddie Greenspan, first of all, was a brilliant criminal lawyer. And his strongest quality was he commanded the courtroom. He had a great sense of humor, and he knew how to use it skillfully. But he took a lot of criticism for his conduct in this case. And later on, there were suggestions even by Conrad Black that, that even he had moved away and was seeking the advice of other counsel in the case. So what I'll tell you this about Eddie Greenspan is that I think there were times in the trial that he did flounder. And I'm sorry, I missed that question, Jen. If you could just post it again, I apologize. He did flounder, there's no question, because he was a Canadian lawyer. This was different system and hard for him. And also his codes counsel, Ed Jensen, who had been the Chicago legend, was at the end of his career, has since passed away as well, had a very completely different style than Greenspan. He was very spontaneous. He was someone who, Greenspan, meticulous preparation. So there was a clash of personality between them. So Douglas's question, in your view, was the government of the United States reasonable? I'm sorry, I didn't see the rest of the question, but I'll try to answer it if I can. And so Greenspan, there were moments in this trial that Greenspan shone, and I'll tell you with two of them. One was he didn't start well in his cross-examination of Radler, but in his last day, when he came back his last day, he was brilliant. And Radler claimed in his testimony that he wasn't aware of the parole availability, his eligibility for parole in Canada, which was silly. The first thing someone knows when they go to prison is what's their release date. Trust me, I've been doing this for decades. Hundreds of people I've defended. They don't care about anything else. The one thing they ask about is, when am I getting out of jail? So the notion that Radler stood up in that court is, I don't know. But here's the funny part of this, okay? So Greenspan wants to retain an expert from British Columbia, to talk about parole and pardon. And so he phones the guy and he says, look, I can't do it. And Green says, well, why can't you do it? He says, well, because David Radler consulted with me. He asked me about all these things. I can't do it. There's a conflict. Radler asked you about this. Okay. Anyways, that came out of trial, Not that we needed that. Anyways, I was just asked by someone, Eddie Greenspan was this lawyer's mentor, and someone asked who my mentor was. And I have had a number of mentors. I had this wonderful judge, Lloyd Grayburn, who I worked with as a law student. And he was just the most wonderful judge. And he let me write some judgments, which of course he redrafted. And he had done the famous case, The Concert for the Blind, for Keith Richards, and took a lot of criticism for it. So no doubt Alan Grant, who taught me in law school. And then I had various lawyers, John Rosen, Brian Greenspan, and Austin Cooper, Mark Sandler. So I had a number of great lawyers who I've worked with. Marie Hennon, who I've done a number of trials with, another brilliant lawyer, just a number of them. I can't really, count them all, but thank you for that question. All right. So I wanted to talk about that. Let me just see if there's something else that I can deal with before we bring our juror in. So Black gets 3.5 years in total in Coleman Federal Penitentiary. At the end of the day, still a huge success given what he was looking at. Let's talk about the boxes for a moment, because I don't want to leave without dealing with that. That was called the smoking gun. All right. First of all, I was leaving 20 Toronto Street, the headquarters of Hollinger International, during the day, knowing the videotape was on. It wasn't like, it was some secret videotape. They put the video in, but let's put that aside. He was being evicted from that premise a few days after the video was taken. He was removing these 13 boxes. He'd already given 120,000 pages of documents to the Securities Exchange Commission. There was no evidence that anything in those boxes was different than anything he'd given to the government previously, and that didn't contain personal items. And so this notion that simply because someone is videotaped removing boxes when they're being evicted from the premise is somehow nefarious always struck me as odd. But then the other point is that if he's not guilty of the frauds, what was his illicit intent? In other words, if he wasn't engaged in fraudulent conduct, so tell me what he was doing that was fraudulent or obstructive about removing these boxes. So I always had a problem with that. But the Court of Appeals sustained that count. So Black had 4 in Paxton, a $285,000 payment, and the boxes, and he served 3.5 years and came out. So I'll just tell you quickly I'll leave on a funny story. So I had predicted that Black would be acquitted on everything. And as I say, I was largely vindicated in the end, because it only matters in the end what the sentence is. I remember my dear father, phoning me up and saying, "What did you do? Why did you do that?" I said, "Well, Dad, that's my honest view of things." He said, "But this is an American justice system. No one wins in America." And he's pretty well right about that. But the story is, I was on a show called The Verdict, and Paula Todd was hosting it, and she interviewed me about an aspect of the case, and I was leaving, and someone grabbed me and said, "You better come on. Our next guest isn't here. We have to talk." I said, "What am I supposed to talk about?" I said, "Well, think of something." So Paula Todd brings me on television. She says, "Steve, sorry to bring you back." Say, "Well, do you want me to give you my prediction in the case?" And that's how I came to make the prediction. And, the title of my book, Tilted: The Trials of Conrad Black, which you saw. The idea of Tilted is really the fact that there were 4 prosecutors on this case. 4 prosecutors. How many murder cases that I've done in my career? 2 prosecutors. 2 prosecutors. 4 senior prosecutors dedicated to this case. The American justice system, I already told you, there's so many aspects of it that are unfair, unjust. I heard Michael Schachter for Peter Atkinson's his jury address saying, we have the greatest justice system in the world. No, you don't. Our system isn't perfect in Canada, but we're way ahead of the American justice system. And to their credit, there are a number of lawyers, law professors, academics who are very critical and are seeking reform. And hopefully that will happen. Excuse me just for a moment. I just want to see if I have anything before I bring them on. Oh yeah, so I'll leave with this story. So after I make the prediction on television, there was this English journalist, Tom Bauer. And Tom Bauer had written a book about Black and Barbara Mill. It was quite salacious. And he wanted to know what inside information I had about the prediction if I'd interviewed the jurors. I said, "Are you kidding me? I'm going to risk my career, go to jail for years, and seek out some juror and find out what's going on." How I came to write the book was interesting too. I was going to Chicago and I came up with the idea, it'd be sort of neat to write this book. But all of the publishers, the major publishers, were terrified of taking it on because it was libel chill. Because Black had already sued HarperCollins, the publisher of Bauer's book, for $50 million. So who wanted to be sued by Conrad Black? And I convinced Dunder & Press, Kirk Howard, the publisher, now a major publisher in Canada, not to worry, that I'm a lawyer, know what I'm doing, and he's never going to sue me. And I didn't. And so when it came time for me to bring Conrad Black onto the synagogue program, I phoned him and I asked, because he doesn't give interviews in Canada. You check, you will see virtually none. And what he said was, "For you, Steve, I'll do it." And I guess, I accrued the benefits of just being fair. I didn't know him before the trial. There's no friendship. I interviewed him. We certainly had our chats during the trial. I remember one chat, this is someone who was writing a book, did a book launch of Richard Nixon during the trial. This is someone who would sit in his home, in his room at the Ritz-Carlton, preparing the footnotes for that book. This is someone who in the hallway at a break would come up to me and say, "Steve, did you hear about what happened in Quebec yesterday. I said, what happened in Quebec? I said, Jean Charest, who's now running for the PCs, he won this election. He was following Quebec provincial politics while he was looking at spending 40 years in prison. That was Conrad Black. So let's bring on now Mr. Kirby. How are you, my friend?
I'm well. How are you, Steve?
Good. Can you hear me?
I can. Can you hear me?
Yes. So I think we better tell everyone how we met, so they don't think we met during the trial. We had these clandestine meetings. We actually met at an interview, as I recall, some television station.
Yeah.
We were both being interviewed, and we had a brief chat, and I wanted to interview you for my book, and you said, great. And since then, we became friends, really. And I remember bringing my son Dylan to Wrigley Field on a baseball trip and meeting you and your wife in Wrigley Field. You remember that?
Yes, I do. I absolutely do.
So it's 15 years now, but I bet you still remember being a juror on the trial.
I do remember that. I didn't recall the 15 years though, until you reminded me.
Okay, but you remember the trial well.
Fairly well.
Yes. So let me ask you this. This is just this incredible opportunity for me. It's like I'm going to the buffet and I can order whatever I want. They're not going to charge me. That's the way I feel right now. So Black doesn't testify, and he sits with his trial during the trial with his arms crossed, and none of the defendants testify. And I don't want to get too much into your deliberations, but just as a general question, do you have an expectation to hear from a defendant, or is that something that you process differently?
Well, they made it clear that it wasn't a requirement, and it wasn't supposed to be interpreted as any kind of admission of guilt or anything of the sort.
And do you feel the jurors respected that? Like they weren't saying, why didn't Conrad Black just get up there and say, I didn't know about these non-competition payments?
Well, it's their decision, and it would have been 4 people. Well, maybe not all 4 of them, but that'd be extending the time of the trial as well.
Yeah. Okay.
But
so
I wouldn't say we.
So I, as a lawyer, I always worry about not calling my client and what effect it has. So I want you to know when I wrote my book, I compiled a list of the top 10 questions for the jurors in post-trial interviews. So I now have an opportunity to go to my book.
Oh no, I don't remember.
So here's one of the questions: were you disappointed when Donald Trump didn't show up at the trial?
I wasn't. Not in hindsight, believe me. At the time, it wouldn't have mattered, but certainly a few things have transpired since then.
Okay. So you weren't disappointed. Okay. And David Radler, what was your impression of Radler when he testified?
Not the most sympathetic, but I believe a good deal of what he said, and I still to this day feel fine with the verdicts.
Yeah, but you understand the U.S. Supreme Court and the Court of Appeals changed the jury's verdict.
Yes. Yeah. But
I feel like I'm cross-examining you now, but I'm not. No, but your verdict, which you reached honestly and fairly, is
I will say that we did the best that laymen can do.
Yeah, and you were out for 12 days, so I just want to talk to you. I don't want to get into the intricacies of it, but generally, what are you doing for 12 days as a jury? What do you?
Well, we had some arguments with a couple of holdouts and people who just wanted to get through it. So it wasn't as smooth that's why it lasted 12 days.
And so were they hung up on particular counts, or was it just they wanted to just?
Well, yeah,
they had their decision.
I mean, I don't really remember all of them, but I know there was one woman who was clearly ready to, acquit on all of them. And then another one who was diametrically opposed.
So that's interesting. We had
to work through that.
So you had a jury listening to months of evidence, jury out 12 days, and you had one juror who was strongly in favor of acquitting on everything, and another juror with the same evidence who was strongly,
and then people in the middle as well.
And then people in the middle. Interesting. What about you get this instruction from a judge. Well, how important is the judge to the jury during the trial?
Oh, boy. Well, I tended to look at her in a favorable light. I thought she ran the trial fairly even-handedly. And the instructions were pretty lengthy, as I remember.
Yeah. What about the fact? Sorry, go ahead, Drew.
No, I was just going to say, Amy St. Eve, I thought she did a pretty good job.
Yeah. What about, there was some suggestion that Conrad Black folding his arms and holding them like this, then the trial damaged him. What do you say about that?
I wouldn't put much stock. I mean, unless someone told you that, I don't know. That
Well,
was
there was
never.
a suggestion. No, we didn't talk to the jury, but there was a suggestion the jurors would view that.
I mean, maybe some did, but I don't remember that being discussed.
So you're looking back in the courtroom and you see all the media there. You noticed us because we would exchange glances all the time.
Sure.
What effect did it have on the jury that this was this big case attracting all of this media attention?
Well, I don't know. We paid attention to the gallery, but sometimes it got pretty dry. So your mind might wander briefly and look at the gallery, but we knew it was a fairly important endeavor. So,
did you know who Conrad Black was before the trial?
That was one of the questions on the questionnaire that we had to fill out. And I knew he was some kind of heavyweight in the media empire, but I wasn't all that familiar with him. And certainly none of the other defendants.
And certainly none of the other. What about the other jurors? Did you get a sense that he was a unknown quantity before the trial?
I'd say yes. Even I probably knew more than any of the others, frankly, which wasn't much.
All right. Was it a good experience for you when you look back on it?
Oh, sure. Yeah, yes. I thought it was an important civics experiment. Whether or not it came out the way you think it should have, or I think it should have, it was a worthwhile thing for someone to go through. From my side of it, not from the defendant's side.
Mm-hmm. Do you stay in touch with the jurors after?
Oh, no. We had plans to kind of have lunch. And then once we got out of that van, we all kind of went our separate ways. Because they have
this interesting experience in United States courtrooms where they have sidebars, where the lawyers go to the side and they talk to the judge and whisper. What do jurors think about those sidebars?
Well, usually you could make some guesses by what was just said in the testimony. So you kind of knew it related to whatever was just discussed. But we took notice.
There were a lot of lawyers in the courtroom. The prosecution had already referred to this, 4 senior prosecutors. You remember them all?
I do, just their faces, I do. Yeah.
Right. And then you had 2 or 3 lawyers for each of the defendants. So it was packed with lawyers. How much of an influence, and I don't want to deal with individual lawyers, but how important was the advocacy to you in your assessment and deliberation in this case? The lawyers' work.
Yeah. Well, I think we kind of had our not favorites, but ones that we thought did a better job than maybe others. So we did talk about the individuals in the room.
And you think that gave them an advantage when they would stand up and question a witness or give a jury address if you had this positive view of particular lawyers? Well,
it probably influenced certain, some things, because I think there was a couple of long-winded ones and maybe some bombastic ones. And
and I don't want to get into names because it's not fair, but if someone's bombastic or long-winded, you think that spills over to their client?
Oh, no. Not in a perfect world, psychologically. Yeah. I can't speak what other people were thinking and not maybe vocalizing.
So in Jeffrey Kramer's opening statement for the government, he said, bank robbers wear masks and use guns. Burglars wear dark clothing and use a crowbar. these four dressed in ties and wore a suit. And, I remember as a lawyer sitting there thinking, my gosh, how can you ever get away with saying that in a fraud trial? This was not a bank robbery.
Right.
Is that kind of hyperbole impact on you at all, or does he just put it aside?
Well, I'd like to say no, but I think they probably looked at us like some rubes as well.
I'm sorry, I couldn't hear you.
They might have looked at us as a set of rubes sitting there in the box that would fall for something like that.
Really? So you felt that?
I mean, I could see that scenario on both sides, by the way.
Right. So the government and the defense, you felt were trying to treat you like you didn't really get it, and they.
Yeah.
So what's it like? What's it like when you come in to deliver a verdict? It's going to be very emotional. You're finding someone guilty. Just take us through the moment where the jury says, "Okay, we have our verdict," and we're walking into the courtroom. What's that?
Well, there was a lot of paperwork before that because there were a lot of charges and there were a lot of defendants. So it took a long time to get the paperwork in order. And everybody had to sign it and all of this. But when they brought us in, that was heavy. That was very heavy when we were going to have to stand up individually and say, yes, I agree with the decision. It was pretty dramatic. And I remember looking at Black because he was first, as I remember.
Yes, he was.
And I believe the first charge, he was guilty. I think a couple of not guilties came later.
Yeah. But then you had Mark Kepnes, who nearly collapsed when he was found guilty. And he was the lawyer for Hollinger International.
Yeah. But I do remember seeing Black's look of disgust when he heard.
Remember that? Did any of the jurors come to the sentencing, to your knowledge?
I do not know. I don't know.
And you were followed by a journalist after the verdict? Am I right? Tom Bauer follows you.
Yeah, I ran into
up to you on a bicycle.
It was just happenstance. He walked up to me. He must have recognized me, I suppose.
Okay.
And I remember quoting a line from, of all people, Donald Rumsfeld to him. I said, "You go to the trial with the jury you have, not the jury you want."
Mm-hmm. Okay, well, I really appreciate your time. It's been wonderful, and as I say, we're friends now. And next time I'm in Chicago, I'll look you up, and hopefully we can have a beer at the ballpark again.
Absolutely, I would love it. I would love
it. Best, by the way, the best ballpark I think in America and Canada, Wrigley Field. So
I won't argue.
You're very lucky. Okay, thank you very much. So,
nice
anyways, with that, I just want to thank everyone and remind you that we'll have now some music from Coldplay, some lovely tunes. I really hope you'll come back for our next program. Again, thank you for joining us. I'm Steve Skirka, and this has been Evenings with Steve. Have a good night. Take care.